Reed, Louise had a question for you. Don't know if drunk driving was involved, but her daughter was in a pretty bad wreck last week, sandwiched between two cars after the one behind her hit her going about 40 miles an hour. Now, that driver was experiencing medical troubles and couldn't stop in time. Does that matter at all when it comes to paying my daughter's medical bills? Meaning this wasn't intentional. This was just something as a result of a medical problem.
Sure. So you bring up a good phrase there, Neil, and that's intentional. And so accidents, car wrecks, they're not intentional. Those, if it's an intentional tort, meaning you did it on purpose, then you don't have insurance that's available. Nobody is intentionally going out trying to get into a wreck. So there is an exception for a medical emergency, but in Georgia, more times than not, you can usually get around that. There's some very tight laws regarding medical emergency. Number one, it has to be a medical emergency that you could not have predicted or did not know. So, for example, if you have congestive heart failure and you have a heart attack, well, you knew you had congestive heart failure, the medical emergency is not going to apply. Also, you have to be unconscious. It can't be. There was a case, I think, out of Marietta that the guy had his foot, he couldn't lift his foot off of the gas pedal, and the Supreme Court of Georgia held that that was not a medical emergency, so the insurance still applied. And that's when the ruling that you had to actually be unconscious when the accident happened for the medical emergency doctrine to apply. So in this case, there is a chance that it could be, they could get out of, I guess, culpability with coverage, but more times than not, there's a way that they're going to be liable for the damage.